You took silk in 1980. Looking back over all the years, is there a particular instance that you're most proud of during your very long career?
Yes, I think so. I think my first case in the High Court is the one that I'm most proud of, a case called Pedersen, Pedersen versus Young. It was, my client Pedersen was a New South Wales man. He was injured in a car accident in Queensland when he was on holidays in Queensland. And the other car was driven by a Queenslander. This was very early in my career. I was instructed by my former master solicitor. The limitation period in New South Wales for such an action was 6 years at that stage, and that in Queensland was 3 years. And we were out of time for Queensland. We didn't commence the proceedings until, say, 4 years after the accident occurred. So we couldn't sue in Queensland. We sued in the High Court, which now you'd have to be the federal court, but we sued in the High Court, filing our proceedings in Sydney and not in Brisbane. And I went up. The defendant pleaded the statute of limitations, the Queensland statute of limitations. I went up to the High Court to see a single judge in chambers with the other side on notice, and the judge happened to be Mr. Justice Owen. And I said I wanted to strike this defence out. And he took one look at it and said it's a bit more serious than taking an application to strike a defence out before a single judge in chambers. I think you ought to file a demurrer. Now, a demurrer is a legal a pleading of law which still exists in the High Court, existed in New South Wales in those days, but doesn't exist because we hadn't at that stage adopted the judicial system. Doesn't exist in Victoria or anywhere else in the world. So I went back and drafted a demurrer, and the demurrer came on before a full bench of 5 judges of the High Court. I was on my own for the plaintiff. We didn't have any money. Morris Byers, I think, leading Dougie Miller, I think, was for the plaintiff, for the defendant. I might be wrong, but I didn't have to say much because Mr. Justice Kitto was the senior judge and sitting in the middle. He did most of my argument for me. My argument was that because the statute of limitations is a procedural statute, it was the New South Wales Act that was relevant because the proceedings had been commenced before the High Court in New South Wales. And in fact, the judges agreed with that. But Mr. Justice Kitto's argument was much simpler. He simply said, and I say his argument because he was the judge. He simply said, but when the Queensland Act refers to a court, it's got to refer to Queensland courts. It doesn't refer to the High Court. So that was. I won on 2 grounds, but against 2 very experienced lawyers. I suppose I was at that stage something like been in practice for about 4 or 5 years. I was rather proud of myself, and I'm not sure, actually, interestingly enough, that the case that I should have won it because there's a High Court case within the last 5 years called, I think, Stevens and something or other, which throws some doubt upon the correctness of Pedersen and Young.
Oh, well, you can still take pleasure on the memory.
My word, even more so.
Conversely, is there a case or are there cases that you feel regret about? You talked to some degree about the Nagel Royal Commission, and I sensed regret in you about that, but are there others?
Yes, I think I might have forgotten them.
Perhaps you have to.
There are certainly cases that I have lost that I don't think I ought to have lost. Now, I can't particularly remember any. There's a case that I don't think I necessarily should have won, a very horrifying case in which involving the CSR copper mine in Cobar, in which three miners working in a weekend were stripping pipes out of a disused vertical mine shaft working from the miner's cage, and all of a sudden, and they were using an oxyacetylene system, and all of a sudden there was a bloody great explosion, and they were all burnt. They were all absolutely burnt to nothing. The allegation was that I was appearing for the mine. The allegation was that the detritus on the side of the mine shaft over the years had come to contain, because this mine shaft was, amongst other things, a ventilation shaft, got impregnated with diesel fumes and so forth, and that the oxyacetylene thing must have set this off. I had a Butte cross-examinations of three experts called by the government, which I think really made them look idiots. But unfortunately, I still think that what they were saying, although their evidence really was very poor, I think that's how it happened, and that we were responsible. I'm sad about that, but I don't think the result was wrong. But I can't. I certainly have
nothing that caused you sleepless nights or long dark nights of the soul.
I do remember one very late case that I had. It was after we had the new system whereby you had to certify that you thought there were reasonable grounds for bringing proceedings, and I was appearing for a plaintiff who'd tripped over while she was a security guard. She'd tripped over while performing her duties while walking around the paddock and looking in the backsides of the various buildings. And the issue was what time it happened, whether it was dark or light, and so forth. And she'd given me false instructions, no question about it. She later admitted it, because she'd started her shift early to allow someone else to go home. And so she'd misstated the time that it happened. And after this became perfectly obvious, she told me the truth. And I therefore didn't feel I could continue to act. I was a bit in the same situation as I've been in the Nagel Commission. And that was one of the, and she lost. If she'd have told the truth in the beginning, we might have won. It was her fault, not mine.
So in a funny way, the truth outs, doesn't it?
Oh, yes. Mm.